Well, good afternoon, everybody. Thank you for being patient while we got the technological issues worked out all the way from Hawaii. Joel Nagel and his family are out in Hawaii. He has some meetings. I think a lot of them are on vacation. I hope he's having a little bit of fun as well. We're going to give it just a minute or two here to let the folks who are logged in get online. That always takes about 90 seconds or so to make sure everybody's with us. And while we wait, one of the things we like to do is just ask folks in that Q&A panel down at the bottom to stick in where you're calling in from. Two things. One, I always like to find out where people are visiting from and who's with us today. But also it gives you a chance to actively engage the Q&A panel, because during Joel's presentation, if you have questions, please jot them down in the Q&A box at the bottom. And a lot of them will probably be answered throughout Joel's presentation, in which case we won't need to answer them. But if there are things that you've asked, or as we get closer to the end, you want to put some questions there, when Joel is finished, I will pick this back up, moderate the Q&A with him. We've allocated exactly 1 hour to do this. We're very respectful of his time, your time, our time. And so he's going to wrap up in about 45 to 50 minutes, and we'll leave 10 to 15 minutes for Q&A as well. So real quick, let me just see. We've got people coming in from Southport, North Carolina, Salt Lake City, Panama. I love it. I love it. Puerto Rico, another one. Puerto Vallarta. Wow, this is great. Sedona, New Zealand. This is fantastic. Getting people from all over the world. Belize, Pueblo, Colorado, Minnesota, Texas, another North Carolina, Costa Rica. This is great. Elizabeth from Portugal. Fantastic. So glad to have you on with us tonight. Well, that's great. And I'm going to dig right in. And maybe what we'll do is we will ask Joel to stay on an extra 5 today, if he can manage that with us, to give up the 5 minutes that we were running till now. But in terms of an introduction, I think many of you know that Joel and I have been friends for, goodness, about 40 years now. I think I did the math right on that. He and I went to college together up in a little college in Northwest Pennsylvania. After college, he went off and became a very, very successful asset protection attorney. And the reason that I am now in the development business in Latin America, it's all Joel's fault. He called me up one Tuesday way back in 1993 and said, "Do you want to go to Belize?" And I said, "Sure. Where's Belize?" He was doing what he did then, still today, which is protecting the assets of people who work hard and deserve to have their assets protected against lawsuits and forfeiture and things like that. Back then, he was working exclusively with physicians. He developed an incredible program called the PAP, the Physicians Asset Protection Plan. That has evolved into a very, very comprehensive business now, including asset protection, of course, but also helping folks find liberty and freedom in second residencies and second citizenships. He's going to talk a lot about all of these various topics today. He's going to touch on them. We call this the 101. It is very introductory. It's a light touch on the various aspects of asset protection and foreign residency. And then if there's something you want to dig in a little bit more, his contact details are right here in front of us today and right now, and they'll be at the end as well. But Joel, without further ado, you've been a great friend, a best friend for 40 years, and it's really an honor to have you here talking today and helping folks understand what's out there, what are their options, and how do they engage them to live a freer and more secure life. So to you, Joel.
Thank you, Mike, and thanks for having me on the program today. It's I should say mahalo, since I'm here in Hawaii. It's still morning. You mentioned a few places, including New Zealand. I think for them it's also morning, but for everybody else, evening and good night. So again, thank you for having me. I'll just mention on this slide the info at nagellaw.com. If you have a question that does not get answered today, please shoot a message there. Also want to thank my colleague, Hannah Kubarni, who's in the office in Pittsburgh there. And she's helping me with the technological aspects today to keep me on track and keep my slides in front of all of you. So I should just briefly introduce her as well and thank her for being on the program with us tonight. So let's go ahead to the next slide and we'll go ahead and get started. This Global Asset Protection for Dangerous World title is a title I've used now for over 30 years. This presentation, which is sort of my introductory presentation to asset protection, it's evolved extensively over 30 years. Imagine all the ways the world's changed economically, financially. You have the rise of political parties. You have the fall of others. You have gold doing certain things during certain periods. The last 15 years, we have the rise of cryptocurrencies and Bitcoin. So the world is always changing. But interestingly, I've never felt the need to change the title, Global Asset Protection for a Dangerous World. We live in a dangerous world. I think anybody, particularly Americans, Canadians, but more and more people in other parts of the world, just by having any wealth at all, you recognize that you live in a dangerous world, because there's always somebody that wants to take that wealth from you, whether it's a government, whether it's an ex-business partner, whether it's somebody who gets hurt in one of your apartment buildings that you own. It doesn't matter. The list goes on and on. And in general, much of the developing world, the legal system has, through democratization, has become very, very pro-plaintiff. So it makes it easier for people without assets to sue people that have assets. So we're talking about protection from lawsuits, but we're also talking about protection from governments, taxation. We're talking about wealth stewardship. How do I pass, real estate? How do I pass wealth from one generation to the next, to the next, to the next, with the least amount of loss associated with taxation? So those are just some of the things we're going to talk about today. And then, like Mike said, try to have a little bit of time at the end for some Q&A. I think there's a mechanism where you can type your questions and send them in, and then we'll have them as soon as I finish with these remarks. So next slide, please, Hannah. So this is what I'd really like to do over the next 40 minutes or so. I'd like to discuss these questions and the answers to them. What is asset protection? Why do we do it? What risks are we protecting ourselves from? What are the benefits of international versus domestic asset protection planning? And what are the most common structures to achieve asset protection? Next slide. So starting off, what is asset protection? It's pretty clear. It's protecting what's yours. I show up at a lot of investment conferences, and every single speaker in the room except me is talking about one of two things. They're talking about how to make money, or they're talking about lifestyle issues. They're telling you, Mike's telling you, hey, you should buy this property in Belize because it's a good investment, or because it's a great place to live. You're going to enjoy spending time there, taking your kids, your grandkids. Everybody is talking about either lifestyle, or, to use the sports analogy, they're talking about offense. They're talking about how to make money. When I show up at a conference, usually I'm swarmed by people, and it's because I'm the only person talking about this. It's defense, right? In any sport, to be successful, you have to have both offense and defense. And frequently people come up to me with questions about offense, and I say, you know what? I don't know. I'm not an expert in that area. There's a million ways you can make great investments. I'm defense. I'm going to try to help you keep what's yours. I'm going to help you protect what's yours, steward it to the next generation, keep it out of lawsuits, keep it from being overly taxed, things like that. And again, to be successful, you really need both, right? Most of the people on this, I see there's about 100 people on the conference now, and really appreciate you taking the time to join me. Most of you have assets. If you didn't have assets, you wouldn't really need to be on this call, right? But once you have any kind of appreciable asset, then you're not only thinking about how to spend it and enjoy it, but usually you start thinking about, protecting it from lawsuits, or stewarding it to the next generation. How do I get it to my kids, my grandkids, maybe great grandkids? We have clients that come to us. They say, well, how do I steward wealth for the next, 10 generations? And there's lots of great strategies to do that. We're going to touch on this. So what is asset protection? Protect what's yours. I love this slide because it's sort of a visual, view of, to me, what asset protection looks like. You have this castle surrounded by a field, and then trees, and then there's a wall, and then there's water, right? Those are the different layers of protection that we're trying to create for clients. All right, next slide, please. So for some people, asset protection is a very complex structure. It could be, a trust in one jurisdiction, a foundation, another company in a third, with assets invested in fourth, fifth, and sixth places. But for other people, it could really just be take your 16-year-old daughter's credit card away from her, right? That's asset protection too. And the reason that I try to point out the extremes is asset protection is different for every person. A lot of times people will come to me and they'll say like, okay, like, do you have this little product on the shelf you can just hand me called asset protection? It doesn't really work that way. It's really trying to understand you, your needs, your wishes, your desires, your goals, your objectives. And then we reverse engineer from where you are to where you want to go, and we lay out the path to get there. And I have had clients that really all they needed was, like this picture shows, to take credit cards and have them destroyed, right? Next slide, please. I also want to talk about what asset protection is not, because particularly when we talk about the international or the offshore world, there's this general idea that, well, I can hide my money offshore. I can by doing that, I'm not going to pay any taxes. Asset protection is not a scheme to evade taxes, right? I don't think anybody here would look particularly good in the Department of Corrections orange jumpsuit there. And the last thing you want to do is contact my office or your accountant, your CPA, or another lawyer and say, hey, I want to do this, that, or the other thing because I intend to defraud the government and not pay my taxes, right? A professional can't even work with you under that circumstance, because then they would be involved in something called a conspiracy to commit tax evasion, and nobody's going to want to do that. So it's not about doing things that are illegal. It's about doing what you can that is legal, right? And that's what we're going to talk about. But still, when I show up at conferences, particularly offshore conferences in different parts of the world, there's always people running around who are, they've crossed the line. I saw one not too long ago. I thought that these types of people, had gone the way of the dodo bird and didn't exist anymore, but they're still out there telling people, oh, do this, wink, wink, nobody's going to know what you've done, and you can hide your money. That's not what this is all about. Next slide, please. So this is I have a big family, as a lot of the people on here know me. I like children's analogies because they can drive home the point in a very simple way. These children think that you cannot see them because their eyes are covered, right? That's the complete misnomer, right? Their eyes are covered. Of course, we can see them. They can't see us. And some people go about international planning, and just like these children, they'll think because they set up a company in Panama or trust in Belize or a structure in Nevis that people can't see their wealth. It's simply not true. You live in a very, very transparent society today. And when you transfer money, for example, to another country, when you go into your bank, whether it's in Pittsburgh where I live, or Texas or California, and you fill out a wire transfer form, that bank is sending that information to the U.S. government in real time. So as one of my banker friends said, the government knows about your transaction before you've even got up out of your chair and left the bank. That's how transparent in real time that we live in. So it's not about hide and seek. It's actually a different children's game. Next slide, please. And that is show and tell. What we're really doing is we're saying, hey, this is what we've done. We are not the low-hanging fruit. We have created the right kind of legal structures and strategies in different parts of the world. And if you think you can go after the assets and get them, go ahead. But it's going to be exceptionally difficult. We're not set up in jurisdiction that's a pro-plaintiff jurisdiction. We're set up in jurisdictions that are pro-defense, right? And I'll give you just a quick story. If I go back to the beginning of my practice days, this is over 30 years. I've been practicing now as a lawyer 37 years. This is probably about 32 or 33 years ago. I was creating a asset protection trust for a doctor client of mine in Pittsburgh. The doctor had just sold their practice to the University of Pittsburgh Medical Center, and they received about $2 million for their practice. We paid a bunch of taxes, transferred the rest of the money to a trust, happened to be in Belize. And a few months later, a litigation was brought against him by his former nurse. It was a whistleblower action that basically alleged that he had defrauded Medicare. He'd improperly been billing Medicare over the years. And the thing is, you can't defraud the U.S. government and have it be just a civil matter. So it became both a civil matter and a criminal matter. And for about 6 months, There were all these inquiries and files being requested and what have you. And at the end of 6 months, the judge in the criminal matter threw the case out. And he said there hadn't been any evidence that had been submitted that indicated that my client had defrauded the US government. And he apologized to my client in open court. He threw the matter out. But that was the criminal side. What about the civil side? No, the civil side droned on and on for several more months until one day we were sitting in a conference room of the law firm, one of the law firms involved, having a deposition, which is a formal court procedure where you swear to tell the truth, the whole truth, and nothing but the truth. You're not in a jury, you're not in front of a jury or in a courtroom, but you are under oath. And the lawyers were asking my client a bunch of questions. A lot of it was nonsense. Where did he go to medical school? Things like that. Until finally they came to the one question that they really wanted to know. They said, Dr. X, you sold your practice. What happened to all the money? And he explained very clearly and succinctly with this sort of show and tell methodology in mind that he had paid taxes. We had transferred the balance of the money to an offshore trust. In this case, it was in Belize. He had information about the trust, the gift tax return that we filed with the IRS, a copy of the trustee's business card, and basically made all that information available. And the eyebrows of the lawyers sitting across the table went up, and they whispered to each other. And then they asked for a short recess so they could go out in the hall with their client. And they came back a few minutes later and said they were going to suspend the deposition, and they'd like to pick it back up later. Well, about 2 weeks after that, the one lawyer called me and said that they had voluntarily dismissed the case. Now, what happened in that little short conversation? Of course, I wasn't there, but I was able to surmise what happened from the lawyer's comments. They basically said, hey, Nurse Jones, we think you have a really good case, but the other side has their assets in an asset protection trust in Belize. It's going to make it exceptionally difficult to go after those assets. We're still willing to represent you, but we're not going to do it on a contingency fee basis anymore. We're going to need a retainer fee. That retainer fee is, $25,000. We're going to charge you $500 an hour. And then the nurse said, well, wait a minute. What happened about the whole, no fee unless we get money for you, which is what all these law firms pitch, on late night TV. And the lawyers came back and said, well, that only applies in domestic cases. That doesn't apply in foreign cases. So at that point, the nurse said, well, I have no intention of writing a big check. And, the whole case went away. So the asset protection didn't come because we were hiding the asset. It came because we were playing this children's game, show and tell. They knew exactly where the assets were. They knew exactly who they had to contact if they wanted to go after those assets. But we changed the paradigm. We changed the game altogether. They were playing checkers and we were playing three-dimensional chess. And they decided they didn't want to play that game. It was going to be too time consuming, too expensive, and they went away. So it was a self-fulfilling prophecy. By showing and telling them exactly what we had done, we created the aura of asset protection. All right, let's keep moving on. Next slide, please. So the great General Sun Tzu wrote a book called The Art of War 2,500 years ago. And he basically said, it really comes down to defensive positioning as a matter of life and death. And to him, before he worried about winning the war, he wanted to make sure that he couldn't lose the war. And that's, to me, again, is what asset protection is about. Again, I'm not telling you how to take your money and multiply it 5x. I'm making sure that you can sleep at night knowing that your money is there tomorrow. And then, you can work with good people like Mike Cobb and others to help you achieve the lifestyle that you want or to make the investments that you want. But our job is to make sure that you can't lose what you already have. Probably the people on the call that are my age or even a bit older might remember the old E.F. Hutton commercial where they say it's not about what you make, it's about what you keep. And that's really asset protection in a nutshell. All right, next slide, please. All right, so now we move to the next section, which are what risks are we protecting ourselves from? The first risk are physical risks. Nobody likes talking about physical risks, but I would say that they play an extremely important role in where you live, where you work, where your children go to school. In the back of your mind, almost any city in any country, anywhere in the world, any rural community, there's places you want to live and there's places you don't want to live. And the physical risks are this sort of unspoken element in the back of your mind. But when we think about asset protection, you start thinking about jurisdictions. Why is something like 2/3 of the world's gold reserve, private gold reserves, in Switzerland? Well, they've been storing gold for 600 years, and no one's ever once taken an ounce of gold improperly or illegally from Switzerland. No one's ever invaded it. So if you take this physical risk concept to a country level, again, it's a self-fulfilling prophecy. No one's ever breached the security of Switzerland, which is a huge attractive feature. That's why if you live in Pittsburgh, where I live, or Texas, or Belize, or Panama, you probably live in a certain area because in your mind you've minimized the concept of physical risks. Next slide, please. Then we have economic risks, and this is an easy concept for most people in the world, but it's super hard for Americans because most Americans, when they think about diversification, they've been told from day one, diversification means, oh, I've got stocks and bonds and mutual funds, maybe a little piece of real estate, and that's what I need to be successful. But if you have that type of diversification, but all of your proverbial eggs are in something called the dollar basket, and the dollar basket depreciates, goes down, or collapses, then it doesn't matter how well diversified you are within the dollar basket. Your assets have gone down or been destroyed. The French philosopher Voltaire said over 200 years ago that every paper currency will eventually reach its intrinsic value, and that intrinsic value is zero, right? So it's just a question of how long it takes to get there. If you have the Zimbabwean dollar, I like to hand out at some of my conferences, $100 trillion Zimbabwean dollar was worth about 23 cents before it became worthless. And there's probably people on this call that have familiarity with Venezuelan bolivars or Iraqi dinars or whatever, you name it. There's so many currencies out there that have gone to zero. And quite frankly, the dollar itself, if we want to measure a dollar by, let's say, gold, I'm not some huge gold bug, by the way, but I think we can all agree that gold is it's a fair ruler because it can't be a measuring stick, let's say, that kind of ruler, in the sense that it can't be manipulated by governments. So if we go back 100 years ago, an ounce of gold was worth $20, and an ounce of gold and $20 would get you a finely tailored man's suit. If we fast forward back to today, an ounce of gold is just under $3,000, and $3,000 will get you a finely tailored man's suit. But the $20 won't, right? It's $20. If you look at it that way, then the dollar has gone down against gold, whatever that is, 96, 97%. And other currencies have gone down more than 99% or 100%, meaning they've gone bankrupt and become worth zero. If we go back to that same time period, the German Reichsmark at that time, over a 2-year period, went from 100 Reichsmarks for an ounce of gold to 100 trillion Reichsmarks for an ounce of gold in just 2 years. So you can see how quickly a currency can collapse in certain circumstances. Now, the U.S. dollar obviously has, it was backed by gold up until 1974 when Nixon went off the gold standard. So we've only been a completely unbacked currency for, what is that, 50 years. Even still, the dollar's gone down appreciably. People in other parts of the world, they do understand this, like I said, better than Americans. So they're used to investing in different currencies, different classes, commodities, gold. In this day and age, we have cryptocurrencies, real estate, anything that can replace the dollar in terms of the economic risk. All right, I think I've made my point on economic risks. Let's move on to the next one. We have taxation risks. And again, there's no magic fairy dust to make your taxes go away, but there are lots of things in the tax code already, and they do apply both onshore and offshore. So, for example, a lot of people say, well, I have all this money. I'd like to move it offshore, but it's in my IRA. Say, okay, great. Well, there's nothing in the tax code that says you can't move your IRA assets offshore. So the assets being offshore isn't what gets you the tax deferral. It's the fact that they're in an IRA, whether it's a standard IRA, a Roth IRA, a 401k. There's also different types of annuities, insurance products. There's really quite a number of ways that you can get legal tax deferral and be offshore together. And I think that's really important. And somebody once asked Albert Einstein, what's the strongest force in the universe? And his response was compound interest. So I think the best way to drive home that point is the old adage about if you take a penny and you double it every day for a month, how much do you end up with? Well, it's a pretty easy thing to do. You take a calculator, 0.01 times 2 times 2 times 2, 30 times, and you'll end up with about 10.4, I think it's either 10.4 or $10.6 million. Now, if you take the same equation and you take that same penny and you double it, but as each time you double it, you take away 40%, representing the top marginal federal tax rate, and then you double it. Not 40% of the whole amount, by the way, just 40% of the gain. Then double the amount. 40% of the gain, double the amount. 40% of the gain, double the amount. It's a little more complex, but it's not that hard to do. And if you do that equation, instead of ending up at $10.4 million, you end up at $64,000. And that really drives home Einstein's comment about compound interest. So, anytime we can do something where we get the benefits of being offshore, the flexibility from a regulatory perspective, but we can keep the tax deferred elements of the US tax code, whether it's through IRAs or insurance products. Sometimes clients will say, well, I don't have an IRA. I don't want insurance, but I still want my money to grow in a way that's not subject to tax. So, okay, well, then you need to look at assets that don't generate income, but only appreciate in value. Because if I set up a structure offshore and I buy gold, undeveloped land, Bitcoin, silver, the list goes on and on. You can buy assets that over time are designed to go up in value, but they don't trigger any taxes because they don't create any income. Now you're going to say, well, but I might need income. We can talk about that. There's ways that you can set up things like a line of credit against those assets, because borrowing against assets is also not subject to tax. So there's always, if there's a will, there's a way. And if minimizing taxation is one of your goals and objectives, it's, again, the offshore element isn't the magic fairy dust, but combining it with some of these tried and tested methodologies. And again, I know there's people here outside the US. You have people in Canada, they're interested in how they invest their RFPs. You have people in Europe that want to look at 101 type insurance products that are designed to get them tax deferral. Almost every country within their tax code has certain ways to minimize tax. All right, next slide, please. All right, then we have litigation risks. They say that a lot of people argue, what's the top spectator sport in America? Is it baseball? Is it football? Is it basketball? No, in my view, it's litigation, right? We are the litigation capital of the world. Every 17 seconds of every minute of every hour of every day, a new federal lawsuit is filed. If you add in state litigation, it drops to about 7 seconds, and even less if you add divorce, which is also litigation, right? If you want to think of litigation in terms of a war, then divorce is a civil war, because you're using the same pot of assets on both sides to fund both lawyers and both sets of litigation. So if you think about us living in a country where every few seconds a new lawsuit's filed, The Canadians aren't that far behind us. Western Europe is a little less. Other parts of the world, it's still not as commonplace where, if you're upset about something, you just immediately bring litigation. We're trying to find jurisdictions where, it's very difficult to bring litigation. And we're going to talk about that in a second. Next slide. So do we have a level playing field in the US? Absolutely not. Are we looking for jurisdictions that are level playing field in asset protection planning? Absolutely not. People ask me all the time, well, what's a jurisdiction that is truly a level playing field? I would say the British system. The British system is very similar to the American system where everybody can have access to the courts, but there are three major distinctions. First of all, they don't allow contingency fee payments, which means you have to hire your lawyer yourself. You have to pay your lawyer. The lawyer's not allowed to charge you on a contingency fee basis. And then then that's number one. Number two, they have what's called a loser pays system, meaning that, if you sue me as a plaintiff and I defend myself and I'm victorious and I win, then you as the plaintiff need to pay not only the court costs and your own lawyers, but you need to pay my lawyer as well. And that has a pretty strong deterrent effect on bringing frivolous litigation. So that's the second item. And then the third item is that if the plaintiff cannot pay the costs of the litigation of the defendant, if they lose, then the plaintiff's lawyer is legally bound to pay those costs. And I find that to be a really solid and strong point because that means the lawyer, if you want to sue me, go ahead, but your lawyer is going to make sure, one, that you have a good case, and two, that you have the resources to pay if you lose. And if you don't have those two things, the lawyer's probably not going to take your case. Whereas in the US, we have these lawsuit factories where they're just out trolling every day. In fact, a lot of young lawyers and big law firms, they're tasked with bringing in 10, 15, 20 new cases every month. And if they don't do that, then, they're going to be let go. So it's a factory where they're just trying to generate cases. And that's what creates this, this pro-plaintiff system that we live in. UK, level playing field. Are we trying to get that for you as our clients? No, absolutely not. We don't want a level playing field either. We want the field tilted the opposite direction. We want a pro-defense system. The old saying is that money flows to where it's treated best. And based on that, if you look at these asset protection jurisdictions that we talk about frequently, Belize, Cook Islands, Nevis, Liechtenstein, the list goes on and on and on. They are jurisdictions that have on the surface a legal system that creates barriers, if not impossibility, at least strong barriers. In Nevis, for example, if you want to sue somebody, you have to place a bond with the court. You as the plaintiff have to put money with the court. And only after you put money with the court is the court going to let the case go forward. Because again, if you lose, they're taking your money to pay the legal costs, the judge's fees, the litigation of the opposing party, right? So you have to be darn sure that you have a really solid case before you're going to bring a lawsuit against somebody in certain parts of the world. All right, next slide, please. So why international asset protection? First of all, no recognition of U.S. judgments. Under the U.S. constitutional system, if you get a judgment against me in one state, then that judgment can be enforced in another state without bringing the lawsuit a second time. So if you get a judgment against me in Texas, and then you can come to Pennsylvania to have that judgment enforced where I live and say, hey, judge, we have this judgment against Nagel in Texas. We want to have it enforced. The judge in Pennsylvania is not allowed to relitigate that case. They have to simply enforce the case because they have this concept under the Constitution where they have to enforce the laws and judgments of other states. But that concept is a domestic internal concept under the US Constitution. It does not apply internationally. So if you have a judgment against me in Texas, the same judgment as before, and then you show up in Belize and you knock on the the door of the bank and you say, hey, I understand Nagel's got some assets here. We'd like to get these assets. They're just going to throw you out. They're not going to acknowledge that I have assets there. And even if you can prove that I do, they're going to say, well, what does this U.S. judgment mean in Belize? It doesn't mean anything because they don't recognize U.S. judgments. So that is really maybe one of the most critical elements of international asset protection planning. At a very, very minimum, if you get a judgment against somebody in your home country or their home country, and the assets are in a asset protection jurisdiction, you, at the very, very minimum, are going to have to relitigate that case a second time. And most likely, it's going to be impossible because the same jurisdiction will have other barriers. They'll say, for example, well, wait a minute, you're trying to sue this trust. What specifically did the trust do to harm you? In other words, if you have, say, a claim against me personally, but my assets are in my family trust, and you sue me personally and you get a judgment against me, now you go to Belize and say, hey, I've got this judgment against Nagel and I want to enforce it. And we can see all the assets are here in the Nagel trust. Then the courts are going to say, well, what's the cause of action against the Nagel trust? Not against Nagel. They're two separate legal people. One's a natural person, one's a juridical person, but they're separate and distinct. And you have to have a cause of action and a claim against that trust specifically. So, probably the most famous case that people have heard about over the last generation has been the O.J. Simpson case, where the family of his ex-wife's lover, who was brutally killed, has been chasing after O.J. and his estate for years and years and years, to the point where they actually were able to track down trusts that he had set up many years before. But that was the key thing, right? Even though they had this judgment against O.J. specifically, that was deemed separate and distinct from the assets in his trust for his children, and they weren't able to ever get those assets. All right. Then you have some other things like a bright line test, which has to do with what came first. It's a chicken and an egg thing, right? Did the lawsuit precede the creation of the trust, or did the creation of the trust precede the lawsuit? So if I create a trust for you in one of these jurisdictions, Cook Islands is a good example today, and then tomorrow somebody sues you, they're going to be out of luck. It's a bright line test. It's very date specific. You have this concept of statute of frauds, which has to do with, did I transfer an asset somewhere to defraud a creditor? Certain jurisdictions have eliminated that concept because you can't crawl in someone's brain and figure out what motivated them to do what they did when they did it. Instead they go for that bright line test, which just says what came first. And then lastly, the bond requirement I already mentioned, like Nevis, where you have to place a bond to be able to bring litigation in the first place. Those are really the core elements why I really love international asset protection as opposed to domestic asset protection. There's lots of great reasons to have both. When you have international assets, liquid assets, foreign real estate, you really want to be on the international side. If you have domestic property, certain domestic assets that you can't move, then you probably want to use the domestic structure. All right, next slide, please. So now we're going to talk briefly about the jurisdictional benefits of being offshore. I'm from Pittsburgh, so I always like to work a slide in from Pittsburgh. This is the famous steel curtain of the Pittsburgh Steelers in the 1970s, not the more recent teams, but in fact, that is a picture from Super Bowl IX, Pittsburgh against the Minnesota Vikings. And I don't think anybody would particularly want to be the guy in purple. When Chuck Noll was hired by the Steelers, the Steelers had been in last place the year before. They finished 1-13, and they got the first pick in the draft. And Chuck Noll picked a guy by the name of Mean Joe Green. And they asked him about that selection later, and it was pretty simple. He said, to build a great team, you need to start with defense. He wanted to convince the other team that they couldn't run, they couldn't pass, they couldn't move the ball. And with even a very mediocre offense, he was able to win this first Super Bowl, Super Bowl IX. It was before we had superstars that were really unbelievable before Franco Harris and Terry Bradshaw and Lynn Swann, and some of those offensive weapons really hit their stride. The defense was what carried the day. And in this picture, Super Bowl IX was the lowest halftime score ever in Super Bowl history. Still to this day, the halftime score was Pittsburgh 2, Minnesota nothing. So who scores the points in when you get 2 points in football? It's a safety. It's actually scored by the defense. So, we had the lowest scoring halftime ever. And, the defense was what carried the day. I think the final score was something like 16-7. So, all right, next slide, please. Tax benefits. There really are benefits in the tax code for people who live and work abroad. In other countries like Canada, the Europeans, the New Zealand, Australia, the tax system is based on residence. So you could be a citizen of those countries, and if you move outside your home country, you're not subject to tax at all. But that's not the case in the US. The US doesn't tax people based on residence, it taxes them based on citizenship. So if you are a US citizen, the only way to completely get rid of your tax obligations is to legally expatriate and give up your citizenship. I get clients all the time that come to me and say, hey, I don't ever want to pay tax again. Say, well, there's only one legal way to do that. You have to expatriate and give up your citizenship. Some of them are willing to do that. Some of them aren't. Now, for those who aren't, you do get a benefit in the tax code that deals with living abroad. So if you live outside the United States, you can get an exemption on the first roughly $125,000 of income that you earn per person. So that's per person. A married couple would be roughly double that. Excuse me. Excuse me 1 second to take a drink. So the income exclusion is important. It's a specific section of the tax code. It's section 911 of the tax code that allows for you fill out a tax form like anyone else. It's a form called 1040-NR, which stands for non-resident, and you basically are able to take a credit against that amount of income. If you make more than that, ordinary income tax rates apply, but if you make less than that, you end up filling out a tax form and not paying any tax. There are other jurisdictions that have specialty tax regimes, some of the US possessions like Puerto Rico. I'm sure a lot of people have heard of the Puerto Rico tax exclusion. It exempts 90% of your taxable income. So if you owe, instead of owing 40% under that regime, you'd only owe 4%. Get to keep your U.S. passport, and if you're willing to move to Puerto Rico and really live there. But that's the caveat. You have to really live there. This Section 911 applies to anybody that lives outside the U.S. But it's not only that you live outside the U.S. It's called the foreign earned income exclusion, and all of those words are important. Foreign earned, you have to earn money, income exclusion. So it's not for passive income. It's not for retirement income. You have to have active income outside the US that you're earning to qualify for that benefit. But if you do qualify, it's pretty nice. A lot of people, if they're self-employed or they can create a business offshore and move abroad, that they can get that exemption for themselves, for their spouse, maybe an adult child or two. I have a client that we've done that now successfully for a good number of years. It's 2 adult children and his wife. They all work in the same business. He's pulling out $500,000 a year, completely legal, completely tax-free. So, all right, next slide, please. Then we have privacy benefits. So you can see the list there, bank secrecy laws. Obviously, with FATCA and things that have come about in the last 10, 15 years, there's a lot more disclosure when it comes to banking and governments and things like that. But you still have solid bank secrecy in jurisdictions when it comes to third parties, whether it's ex-business partners, ex-spouses, anybody that you don't want to know your business. You can have a lot more secrecy when it comes to your banking than you can, let's say, in the US or Canada or Europe, where there's just a lot of disclosure. Corporate secrecy, IBCs, bearer instruments. The bearer instruments are sort of going the way of the dodo bird, but there's still jurisdictions where you can have a bearer instrument. Usually there has to be a local agent that can keep track for criminality purposes if a bearer instrument has been transferred to somebody. But again, it's a way that you can easily, discreetly transfer a company and the assets in the company, whether it's real estate or different types of investment dollars that are inside a company, can usually be done much more discreetly with an offshore structure than passing through probate and passing through domestic rules and laws. And then trusts and foundations, that's really where we have the biggest focus of my law practice are on trusts and foundations. And again, it's because those types of entities are considered separate, distinct legal a separate, distinct legal person for tax purposes, for litigation purposes, for estate purposes. If I put an asset in a trust today and then I die tomorrow, like the asset that's in the trust isn't mine. So it's not going to go through my estate. It's not going to go through probate. It's not subject to my will. It's governed by its own document because that trust is separate, distinct person. Once I transfer the asset to that trust, it's no longer mine, and the disposition of that asset within the trust is going to be covered by the language in the trust itself and no other document. Foundations are civil law versions of trusts. Napoleon really didn't like the English common law. I could give a whole presentation, kind of comparing and contrasting trusts and foundations. Maybe we'll do that some other time. But in a nutshell, the civil law didn't permit trusts to exist in the civil law world. So that's France, Germany, Spain, Latin America, those parts of the world, Asia, until the early part of the 19th century, or latter part of the 19th century, when eventually foundations, which are sort of hybrid vehicles, they're governed slightly differently, but they are, a lot of times people refer to them as civil law versions of trusts. So they are separate, distinct legal persons, and they work really well. Certain jurisdictions like Panama are well known for foundations. Liechtenstein, Switzerland, Austria, they all have foundation law. Okay, next slide, please. All right, so we have now estate benefits. These types of structures can avoid what's called the rule against perpetuities. That's a 500-year-old English common law concept that says that essentially you can't leave an asset into perpetuity. But again, why is that? If you make money, you pay tax on it, it's legal, and you say to me, Joel, I want to put that in a trust for my heirs for the next 1,000 years, why shouldn't I be able to create that kind of structure for you? So a number of jurisdictions have eliminated the rule against perpetuities. Belize, for example, is a jurisdiction where I do a lot of work. They had a 120-year trust law, and now there's some revisions to the trust legislation going through right now. I think they're going through revisions, should be law by early this summer, that are eliminating that 120-year rule altogether. So they're doing away with the rule against perpetuities because, again, money flows to where it's treated best. And if you say, hey, I only want my heirs, for example, to be able to access income from a structure, not the corpus. In fact, I want the corpus to grow. I want it to keep up with inflation. I want it to be there for my heirs many generations in the future. Why shouldn't I be able to do that? I just read a really cool article the other day. Japan has the most protective rules when it comes to wealth transferring from one generation to the next. And over half of all the companies in the world that have been around for over 1,000 years, you heard me right, 1,000 years. Imagine that. The U.S. is a quarter of that age. But there are companies in the world that have been around 1,000 years. Over half of them are in Japan. Right? It's because their legal system doesn't embrace this British rule of perpetuity, or the rule against perpetuity. It allows for perpetuity. And what that means is you cannot have an estate tax, which has been a very common concept under English common law. It's been a political football in America for many years. We have right now an exemption from gift and estate tax, but that exemption has a maximum threshold right now of about $14 million. Japan doesn't have that concept. Other countries don't have that concept, which means you can allow for the accumulation of wealth to pass generationally and stay within a company. One of the companies I was reading about is a hotel. It's the oldest hotel in the world. It's been around, I think, 1,400 years. And it's been in the same family 1,400 years because the government, if it was if it was under the British rule, for example, well, I guess if it belonged to the British monarchy, which didn't subject itself to estate tax, but anyone else, that would be virtually impossible because with each generation, a portion of that wealth of that company, that hotel, that real estate, whatever it is, would have to go to the crown, right, or to the government. So by putting assets in structures that go against this concept of rule against perpetuities, you really can have maximum control from beyond the grave. If you want to administer an asset in a trust for 1,000 years, you can. And I'm seeing that more and more. Clients want that. Not only are they trying to project their wealth many generations, but it also minimizes money being squandered by their children, by their grandchildren, right? If you leave $500,000 to an 18-year-old, what are they going to do? They might go buy a Ferrari and then, wreck it into a telephone pole, maybe kill themselves, right? But if that money is in a trust for perpetuity, they can access the income to maybe get help them with their college expenses or to put a down payment on a home or something like that. But beyond those specific things, the money is going to stay in the trust and grow. That's really what a lot of people want when it comes to these types of structures that defy the rule against perpetuities. I could give a whole presentation about life insurance. I wish I had more time to talk about that. I'll just say that it's really the last major loophole in the tax code because wealth can build up tax deferred and it can come out tax free. It's really the only type of vehicle that can do that. Why? I don't know why the life insurance companies spend lots and lots of money lobbying Congress to keep those special rules in place. There's only one challenge to the concept. For it to work, you have to die, but everybody has to die. So if you're planning it to be a vehicle to have wealth stewardship, it's a wealth stewardship vehicle. And I have clients, instead of using themselves as the measuring life for a policy, they're going to pick the youngest adult that they have access to, whether it's a child, a grandchild, even a great grandchild. They're going to insure that life. And then the policy is going to be owned by maybe a dynasty trust or something like that, so that if all the rest of the wealth gets consumed or spent over several generations, then when that, let's say, grandchild passes away, a massive amount of money is going to come back into the trust structure because it's had a long time to grow, just like we were talking about before, in terms of growing much faster because it's not subject to taxation. So if you can have assets growing over a 50-year period, then come out tax-free, that is really one way to ensure that your structure that's going to go on, let's say, a trust for 1,000 years is going to be able to fund itself. And then avoiding probate and forced heirship rules. We don't really have that in the U.S. with the exception of Louisiana, but other states and the countries do. France, for example, Austria, Germany, some of the Latin American countries, they have forced heirship rules that say you must leave X percentage of your wealth to, let's say, a child or a spouse or whomever. But these types of offshore structures help avoid those rules. All right, next slide. And then I'm running a little bit long on time, and I want to be respectful of everyone else's time. So I'm going to just quickly touch on the most common structures and strategies, and then I'm going to leave it there and try to answer a few questions. So when people come, sort of knock on our door and they want to talk about the most common types of international structures and strategies, this is really the main list. If I put together a comprehensive list, it'd be like 30 things, but these are probably the most important 7. I'll just touch on them. So we have trusts. You have 2 kinds of trusts. You have revocable and you have irrevocable. A revocable trust is not really an asset protection strategy or structure at all. It's designed for one purpose. It's to avoid probate. Lots of people have them. They put their primary residence in them. Why is it not an asset protection structure? Because by definition, it's revocable. And if you get in a jam, somebody sues you, the judge just says, okay, you have this revocable trust with all your wealth in it. I want you to revoke it. And if you don't do what the judge says, now you're back to wearing the orange jumpsuit. So that's revocable trust. Then you have irrevocable trust. And irrevocable trust creates this distinct juridical person, this new person. It's not you, and it's not the beneficiary of your trust. It's separate and distinct. Okay. And by being separate and distinct, that's what sort of gives you the power to be able to control assets, keep them, hold them out of harm's way. And unless somebody has an independent cause of action against that trust structure, that irrevocable trust structure, they will never, ever, ever be able to touch those assets. And I'm always cautious to say this, but it's a true factor. I've been doing this 37 years, and never, ever, ever once has a client who's put one penny in an irrevocable trust lost it because somebody was able to grab it or seize it. They may have made terrible, stupid, idiotic investments with their irrevocable trust. That's on them. That's the offense. We don't get involved in that. But never have they put an asset in an irrevocable trust and then had somebody come along and just take it, whether it was a government, whether it was an ex-spouse, whether it was a business partner, whether it was a plaintiff, who got hurt on your property. And obviously we're a fairly small law firm operating in Pittsburgh, but in the course of 37 years, we've structured, created, opined, been involved with over 3,000 irrevocable trusts, and that's a pretty good track record. Never once has a client lost a penny that put money into a structure like that. I don't think you could say the same for domestic trust. There's lots of creative plaintiffs lawyers out there. They're going to be able to pierce the corporate veil, the trust veils, and get at assets, even if they're in trusts. What I just said applies also to foundations, which we've set up in common law countries. Again, if it's a asset protection foundation, not all are. You have nonprofit foundations, for example. You have specific purpose foundations. But if it's an asset protection foundation, we need to build in the same kind of asset protection features as an asset protection trust. Then it would fall under that general umbrella. Companies, everybody understands a company, but I tell people a company is one-way protection. It's a shield that you hold out in front of you. And when the flaming arrows are being pointed at you and you have that shield out there, it is going to protect you. But the converse is not true. If somebody sues you and gets a judgment against you, and you say, oh, well, I have all my assets in a company in Nevis, that's not going to help you at all. In fact, the judge is just going to say, okay, great. Well, I think you should turn the corporate stock of your Nevis company with all your assets in it over to the plaintiff. And if you don't listen to what I say, now you're in contempt of court. You're back to the orange jumpsuit. So companies protect you from the activity of the company, but your activity does not protect the company from things that you do. So you have to keep that in mind. There's a place and a purpose for both. Trust is transferring it to a separate legal juridical person. The company is a shield that you hold out in front of you. Insurance we talked about briefly. Again, there's a lot of cool things you can do with insurance to get tax-deferred growth. It's also quite a good asset protection structure in the sense that it's generally it cannot be attached by plaintiffs when you have, let's say, a life insurance type policy. Number 5, non-reportable foreign assets. Well, that used to be a huge, long list. And over the last 20 years in particular, that list has gotten smaller and smaller and smaller. And we're down to basically 2 assets. You have real estate, which makes guys like Mike Cobb super happy because, if you buy a beach lot in Belize and you just let it sit there and do nothing, you don't have anything to report. There's no income to report. And the existence of the asset is non-reportable. The other area that's non-reportable is in the precious metal complex. It's gold, silver, platinum, palladium, precious metals that are in bullion form. Why is that? I have no idea, except maybe a bunch of IRS agents had all their wealth stashed away in Switzerland in gold bullion. They didn't want to have to report it, so the rules specifically exempt that. And if anybody doubts what I'm saying, if you go to the Foreign Bank Account Report, which is an IRS publication, you can scan down through it and type in gold, and there's a whole section, a Q&A on gold. And I disagreed on this point with several of my colleagues for many years until finally somebody just asked the IRS, is gold bullion a reportable foreign asset? And they gave the scenarios where it is, which is like a Perth Mint certificate, or if it's sitting in a foreign bank account and it's represented by a paper statement, then it's reportable. But if it's in bullion form and sitting in like a safe deposit box, something like that, it's non-reportable. That's directly from the IRS. Foreign residency, Mike mentioned residency and citizenship. I would say, again, last 10, 15, 20 years, that whole element of our business has just exploded. It used to be one kind of strange person in the back of the room that wanted to talk about foreign residency and citizenship. Now it's very, very common. I would say more than half the clients that we take on, they do want to pursue foreign residency, foreign citizenship, whether it's ancestral, something from their parents or grandparents that they reestablish, or through investment. You have a lot of countries where if you buy real estate or make an investment of a certain amount, anywhere from about $100,000 to $500,000, some are more. I spent a lot of time in Austria. It's about 7 million euros in Austria, but that's a extremely high jurisdiction. They really don't want a lot of citizenship through investment. They take about 100 a year. But other countries, Nevis, for example, really pioneered Nevis St. Kitts, this kind of investment based on, or foreign citizenship based on investment. And they do several thousand a year. It's a pretty big business for them. And then the very last thing I'm going to mention is debt. And you're going to say, well, Joel, debt's not really a structure, and it's not, but it is a strategy, and it's an important strategy, particularly on assets that you can't pick up and move. That's primarily real estate. So if, I could put a piece of real estate in a foreign trust if I wanted to, but it wouldn't really help me because the property itself is located in the US. And courts are always going to have jurisdiction over US property, regardless of whether the owner is a domestic person or a foreign person. Debt can solve that problem. What debt does is I leverage debt. Let's say you're a physician and you deliver premature babies for a living in New Jersey, right outside of New York City. This is an actual client of mine, by the way. And being sued is a everyday occurrence. If something's not right with the baby, they're going to get sued. They know that. So they have a $5 million home and they can't really protect that home. So what do? They convince the bank to give them a line of credit or a mortgage on that property for $4.8 million. They take that cash, they move the cash offshore, they put it in a foreign trust, like the kind of trust we're talking about. And then they just service the debt every month. They don't ever let the debt go away. They just let it sit there. Now you're a plaintiff, you sue my client, you say your lawyer finds out, hey, you've got this swanky home in New Jersey, right outside of New York City. It's worth $5 million. We're going after it. And then you find out that Bank of America has a mortgage on it for $4.8 million. Oh, and there's an outstanding line of credit for $200,000 with another bank, which means the debt equals the value of the property. Are you going to keep going after that property? Probably not, because maybe you win a judgment and then the judge says, okay, let's have the property sold at a sheriff's sale. Well, they sell the property at a sheriff's sale. What happens? Unless it sells for more than $5 million, the bank's taking all the money. No plaintiff anywhere is going to jump ahead of Bank of America, right? So that is the strategy. Debt is a very important strategy on real property. We use it all the time. Sometimes it's referred to as equity stripping. So I could go on, and it maybe just go to the very last slide with our information, which we could just leave that up there. Thank you. And I'll try my best to take questions for as long as I can, or until we're out of time.
All right, Joel. Well, thank you. Great presentation as always. Let me see. We do have a couple questions in here. One, I think, is an easy one. Is this specific to U.S. citizens and residents?
Well, it's a good question. No, I mean, look, other countries don't necessarily have the litigation epidemic that we have in the U.S. But again, there's lots of reasons why people do these types of structures and strategies. Litigation advanced litigation planning is part of it. And maybe if you're, let's say, German, that might not be as important. But when it comes to the estate side, um, wealth stewardship generationally, then I think it applies really the same. And again, I think as people become more mobile in the world, they live around the world, they have assets around the world, it makes sense to have these types of structures just to kind of keep everything together and then lay out the plan as to what you want to have happen to your wealth when you're no longer here.
Great. I'm going to answer the next one. Is this recording available afterwards? The answer is yes. A full recording of this presentation will be sent to everybody who registered for the email or registered for the webinar. You'll get that by email. Next question, and it's the last one so far. We'll give it another minute for anyone else to send a question in. But what is the difference between a family office and a dynasty trust?
Oh, great question. I mean, look, a family office is sort of a generic description of, the idea or the strategy that we take our personal assets and our personal investments and we put them under something called a family office, which means we're going to run it like a business, right? So I don't just have a few passive investments. I run my assets like a business. So I might have investment advisor and a lawyer and a CPA, an accountant. Then I've got strategies for how decision making occurs now and in the future. And as part of a family office, I might utilize, in fact, I most likely will utilize a trust, some kind of trust, whether it's a dynasty trust or even just a simple trust, because it is the vehicle that helps steward the asset from one generation to the next. So the family office is the idea or the strategy to do that, and then the trust is sort of the backbone that holds the assets legally. There's no legal entity called a family office. The family office is it's just nomenclature that you're doing your best to run your assets like a business, and you're trying to build these succession elements into them. um, I've had a family office personally now for about 4 years, and it's a constant work in progress. We're constantly adding this bell, this whistle. Um, as long as I'm around, I'm the guy who set it up and want to have the most impact and influence. But I'm also training, grooming, several of my children to be able to be that decision maker in the future. But that is very separate and distinct from a legal entity called Dynasty Trust, which becomes the owner of assets, maybe a piece of real estate or a gold bar, a Bitcoin, or whatever the asset is. So a Dynasty Trust is a legal owner, and a family office is really just the nomenclature for trying to have an ongoing strategy to protect and steward and grow wealth generationally.
Very good. All right, we have more questions coming in. We're starting to push into the wee hours here. Let's go with really short answers. Do you handle Canadian clients?
Yes, we have, I would say, after Americans, Canadians and Germans are our two most common.
Excellent. How would I schedule an initial consultation, and who should I meet with?
Well, if you send a note to on the board there, info@naglellaw.com, Hannah or Mary in my office will get back to you and set up. We offer a 30-minute complimentary consultation to kind of understand what your needs are, and if we can help you, we're happy to discuss what that looks like. And if we can't, we'll refer you to somebody who can.
Very good. Michael from Panama, thank you for the kind comments and for joining us this evening. A couple more questions. Let's see. What additional consideration should a dual U.S. Canadian citizen take when estate planning? On the American side, does your firm have experience in this? Why don't you just answer the question? I think that's a deep question. Does your firm have experience dealing with U.S. Canadian dual citizens? And could you help somebody with their challenges, maybe?
Yeah, and you do have to do some planning on both sides. Again, The U.S. side is based on citizenship. The Canadian side is based on residence and like where the assets are located. And these types of international structures can help a lot. They won't eliminate your U.S. tax issues, but they could eliminate your Canadian ones. So yes, we do have experience with that.
Great. Did you say the most bulletproof structure is an international irrevocable asset trust versus a domestic irrevocable trust?
Yes.
There we go. Ah, see, that was good. Yeah,
We're in the bullet round, so
we are.
I could talk about that for a long time, but yes is the simple answer.
Do you recommend that foreign real estate be held in a foreign trust? Do countries such as Portugal allow property to be held in a foreign trust?
Yeah, there's two questions there. We definitely recommend, look, if you have a $10,000 beach lot somewhere and you don't want to own it in a structure, no problem. But when you start getting assets and properties worth more and more and more, and you want to not only have the asset protection element, but the estate planning element, wealth transition element, I would highly recommend it. And there are jurisdictions, you mentioned Portugal. Portugal is fine with foundations. They're not crazy about common law trusts. But frequently what we do for clients that have common law trusts is we interpose between the foreign trust and the property a company. So you can have a company, whether it's a Portuguese company or it could be a Malta company or a Belize company, wherever can be a company that owns that real estate. And then you gift the shares of the company up to the trust. That way, the trust doesn't directly own the property. It indirectly owns it, but it can still dispose of it in the future.
We have two more questions, so we'll get to those in a second. I just want to make a comment. Joel, one of the things that has always impressed me, and I know it's impressed your clients because you've served them in incredible ways, is the creativity that you bring to this business, right? Helping people with all the myriad variations of trust with companies and which countries to have a company in and where to get your trust and how they all relate, because it is an exceptionally complex scenario. The world is complex. Countries have different laws, regulations, but you are absolutely the master of figuring out what the client needs, what their goal is, and what structures around the world help them achieve it. I've got to say, just absolutely blown away by the genius. No, but really the genius that you bring to this solution providing for people. It's incredible. All right, two last questions. Not sure I really understand this question very well. Nonprofits, strategy for 1+ million short term. Is that, can you go with that?
Well,
I'm not sure what it means, but.
yeah, I mean, I can kind of surmise. I mean, a lot of work in the nonprofit space, the structure has to be done onshore to meet, for example, in the US, the 501c3 regulatory regime. That doesn't mean the investments can't be offshore once that domestic entity is created. But if you, for example, create a foundation in Panama and say it's a nonprofit, the IRS won't agree with that assessment. You have to jump through the hoops and hurdles in the U.S. to make it such. So I don't know if that question was a different question. Shoot me a note at info@nagolaw.com.
And
we'll kind of respond.
And I know you do charitable remainder trusts too. I mean, that's a whole way of kind of getting into that charitable kind of thing. It's not quite a nonprofit, but I know you've done some work with folks on that very
Yeah,
successfully as
and
well.
again, that's onshore domestic, right?
Yep. Okay. Last question, Charles. Here we go. I am in Canada looking for residency in Panama or Belize. Should I set up and finance a trust prior to moving, or can this be done anytime? Can RRSP be transferred before it is locked up by the Canadian banks? Should this be done before I hit 65?
Yeah, there's a lot of questions there, and I'll just
There are.
touch on them at a very, very high level. For Canadians, the issue is whether you're resident or non-resident. So as soon as you become non-resident, it's not really that critical that you do it in one order or the other. It's more important the opposite way when you have an inbound person, let's say somebody from Asia that's moving to Canada and they're about to become a Canadian resident. For them, pre-immigration tax planning, creating the right kind of structure is essential. But for a Canadian leaving, it really doesn't make any difference which comes first. With regard to the RFPs, RSPs, the the Canadian rules are much, much more restrictive than American IRA rules. They just give you a list of certain things you're allowed to invest in. Generally, you cannot take your RSP offshore. They do have a mechanism so that you don't have to pay the tax all at once if you decide to leave, if you decide to move abroad. You can keep the RSP in Canada if you want, and then you set up a schedule whereby you draw down a certain amount. That amount is still going to be subject to tax, or you can take a lump sum distribution, but then you'll pay a lump sum tax on it as well at a pretty high Canadian rate. So I think maybe there were a couple more elements to that question, but again, if you want to send me a note, info@nagolaw.com. Mike, thank you for your kind comments. I do love the offshore world because it is a blank slate, and it gives us a chance to be creative as practitioners. I do love that element. And the last thing I'll say is I know you, along with Escape Artists Magazine, are sponsoring a conference at the beginning of May in Vegas. Maybe you want to put a little plug in for that. I will be there. I think I'm scheduled to speak 2 or 3 different times, and also always happy at those events to meet one-on-one with people and hear more about their specific needs. But in the meantime, if I can answer anybody else's question, you can always send it to me, info@nagolaw.com. Thank you.
Great, Joel, thank you. And you're right. I look forward to seeing you in Las Vegas for the Escape Artist Conference. You are on the schedule 3 times. We're going to put you to work.
What are those dates again? Because I don't even have them here.
May 3rd and 4th at the New York Hotel in Las Vegas. It's all day Saturday, all day Sunday. It's a 2-day conference, starts at 8 in the morning, goes till 6 in the evening, both days. Jam-packed, great speakers. Peter Zipper, another person that many people have known over the years, will be there, and we've got a tremendous program. So if people are interested in that, and you send an email to info@nagolaw, and you're interested in the conference, just make a note of that, and we'll make sure you also get the registration information for the conference.
Yeah, and I'll just say that, and I love speaking at all those events again because we're the only people talking about defense. But then once a year, my firm puts on an event. It's always in November. It's 3 or 4 days of just focusing on asset protection, estate planning. We go a lot deeper on a lot of different topics. We talk about foundations. We talk about insurance. We talk about tax efficiency. We have a lot of great speakers. If anybody's interested in that, it's a more intense, higher level event, and it's also rather expensive. But if you're interested in really drilling deep on this topic, let us know about that as well.
Yeah, President's Week is phenomenal. This would be what, your 27th President's Week? I think 27th annual or something like that.
Yeah, hard to believe, but yes.
Yeah, and you really do bring in a lot of great speakers, and then you also invite me, so thank you. Um,
Well, you're always in the great speaker category. But thanks
Man,
for
Joel, it's
having me
fun
today.
to be with you, even though we're, what, about 5,000 miles apart right now. Thank you for being here this evening, and enjoy the rest of your time there with your family and vacation, okay?
Thank you. Take
All
care.
right. Thanks, everybody, for joining us. Good night.